All right. Well, look, now we're going to bring on our next speaker, and he's a great friend of mine and all of our working families here in Kentucky, and somebody that's been, working with us here at the State Federation and all of our unions for many, many years now. He's been doing great work to try and make sure that workers are being treated fairly and getting the benefits they deserve under workers' compensation. He heads a group called KEG, which is Kentuckians for Economic Growth, which has over 100 plaintiff attorneys in workers' compensation bar as members. And, we subscribe to their listserv and their email list, and, can really see the value of having the interaction between all of these different attorneys that are representing working people and sharing their, cases and the information that they're getting about different, venues and judges and everything like that. And I want to thank Ched for the, really diligent and hard work that he's done, and really, puts so much into it. And I just want to, say thanks to him, and let's bring on Ched, and he can give us an update on what's going on with workers' compensation in the state of Kentucky.
Well, thank you, Bill. Can y'all hear me all right?
We can.
Good, good. Thank you very much for that very kind introduction. I also want to tell you a little bit about KEG. That I think has really been good for us as part of being a team. We have worked with the AFL-CIO interest in legislation and also in regulations, and also a feature Amicus Briefs. And for those of you that don't know, Amicus Briefs are where briefs are filed at the Supreme Court normally on behalf of the AFL-CIO at no expense to the AFL-CIO. And what our group does is we monitor what we consider to be key legal issues that are working its way through the court. And we ask the AFL-CIO to support and to participate by being an amicus. And it has helped. No question. I can point to some of the cases, but we really appreciate the state AFL-CIO, you, Bill, and your executive committee for participating that way. Now, when I'm in person, I normally like to ask everybody to raise their hands. How many of you actually have sustained a work-related injury and had to fool with the system for benefits? We'll have a few hands. But then I ask, how many of you receive calls from your members and they're calling for information and they have complaints about not being able to get their treatment, being denied treatment, having trouble finding attorneys, and taking forever to resolve their claims? Well, guess what? Those complaints, your members are right. They're legitimate complaints. Don't just shield to them. Try to do what you can to help them, because that's the system we right now. That's the one we have. It's a real simple system. What the insurance companies and the big companies, what they don't pay out for injured workers, they get to keep. And that's something we have always argued and always submitted. We need to make sure that injured workers get their fair shake, and also they're able to get their benefits that the statute and the law says they're entitled to. Today, injured workers across the state are having trouble, especially the rural counties, even finding doctors who will treat with work injuries. And it's really bad in the rural areas. But I'm here in Louisville, and guess what? My primary care physician, it's a Norton's facility, 6 doctors, they will not take or treat workers' comp cases. Significant. You wonder why. You also have in the rural areas, it's really difficult to find attorneys today who want to practice and take these cases. There's reasons for that as well. But the bottom line is that there's been delays in treatment and there's delays in the process. Now, in 2018, many of you have read about this and know that there was a major reform. And what they did with House Bill 2, they took all the cases that the Supreme Court of Kentucky had ruled in favor of the injured workers, cases that the loyal opposition was opposed or did not appreciate what the final decision of the court was. And they basically redid the statute and changed it. They made it retroactive. Bottom line is they took benefits away from injured workers. And we've talked about that a little bit. For example, they took away medical benefits that limit now medical benefits to 15 years. Yeah, at the last 60 days, an injured worker, it's their responsibility, can pop up and he can basically ask for an extension of his medicals. He has to get a doctor, he's got to get a lawyer. And are they going to do that in the last 60 days? No. So effectively, medical benefits were trimmed from lifetime for a work injury down to 15 years. And ask how many of the injured police officers and firefighters and first responders who happen to get an injury how that sets with them because they only get benefits for 15 years. We have trouble finding attorneys, finding the doctors. And so we've been working on the reforms that have been, and we're trying to do things with the administrative aspect. And that's the statute also adopted treatment guidelines and the prescription formulary. Today, a doctor has to go by those guidelines to basically be able to treat a patient. And if it's not inside the guidelines, they're not permitted to treat. They're not permitted to get those benefits. Now, the purpose and intent of the Workers' Comp Act, it was designed back in 1916. Think about that, 105 years ago. And the overall purpose and intent of the Workers' Comp Act was the early delivery of medical and disability benefits and the speedy resolution of compensation and disability issues and fairness. Now, Governor Beshear and his team, they understand workers' comp and the purpose and intent of the Workers' Comp Act. The governor, who I've known for many years, he understands that. He understands what these principles mean. When he looks at a workers' comp case, he looks at it in the eyes of an injured worker, an injured claimant. Secretary Roberts, who's been secretary before and served initially in this administration, I've known Larry for, and I hope he's watching, we've known each other and worked together since the 1970s. And he knows, he understands the injured workers and what workers' comp ought to be. And now we have Secretary Jamie Link. I've met with Secretary Link a couple of times. And what I was really impressed with, I tell by looking in people's eyes, I'm sure you do, but also his comments. And he gets it. He gets it. He understands what the purpose of the workers' comp is, what they're supposed to be doing. And then the person I want to praise as well is Commissioner Rob Walker. And I want to tell you, for our particular purposes, Rob Walker is the first attorney from the plaintiff side, the claimant side, since the year 2020 to be the commissioner. Now, how do I know that? Because since 2000 to become the commissioner. How do I know that? It's because back in 2000, I was the commissioner. And it's been that long before we've been able to have a plaintiff's attorney to come back in the department and to basically help with the administration of the Workers' Comp Act. So I really want to thank Rob Walker for taking this position, giving up his practice. But let's talk about what's been happening. Because of the pandemic, you have Zoom. We're doing Zoom like we're doing today. We now do all our hearings, our depositions, our meetings, conferences via Zoom. Now, you may think, well, okay, what's important about that? Well, it's good, not only in the interest of safety, but an injured claimant up in Ashland used to have to drive to Frankfort, Pikeville, Northern Kentucky to basically have a meeting with the judge. They don't have to do that anymore. They have to be on this Zoom and they can do it from their home. They don't have to miss work. They don't have to have their wife or a friend take them that distance, take a day out or to pay for that. We've also, the governor here recently increased the number of ALJ positions. There were 15, they're now 17. Why? Well, guess what? The more judges you have, the quicker the administration and the adjudication of workers' compensation cases. It's very, very significant. They've also developed, which I find is tremendous, they developed a mediation program. Now, you all are familiar with mediation. You do a lot of mediation with your grievances. But workers' comp had not really done a lot of mediation. And I want to salute and take my hats off to the chief administrative law judge, Judge Gott, from out of Bowling Green. He basically took upon himself, it was in the statute, to develop a mediation program. And what's beautiful about it, it's an earlier delivery of medical benefits and care, coming back to what they set forth in 1916. And it's also an earlier adjudication of the cases. And he has done several hundred, and his success rate for mediation, which I find is just admirable, is over 92%. And that's been fantastic. So look for that. If your members talk about mediation in comp, that's what's happening. Their lawyers will explain to them, but I see it's a very significant step forward. And again, want to thank the Beshear team, especially Secretary Roberts and also the commissioner and also Secretary Link for really putting this into place and supporting the development of that program. We also have been working on for the last year and a half, a medical director. And I told you why are doctors not wanting to see workers' comp cases? Because they have to apply for authorization of their services. It has to meet the medical treatment guidelines that have been adopted, and they also have to reach out and have it reviewed. It's called utilization review. Now, utilization reviews is actually governed and controlled by the insurance companies. Now, think about that. The appeal of UR is currently controlled by the insurance companies. What a medical director does, a medical director comes and he's a doctor. He's trained to make medical decisions, which will result in early resolution. The process that we've been talking about is 6 weeks instead of 10 to 12 months. What's wrong with that? And according to the ODG treatment guidelines, the speakers from that organization, who now are part of Kentucky law, it says it resolves 90% of the medical disputes in Kentucky. It will. Kentucky's one of 11 states that have adopted it, and we're only one of maybe 2 that have not adopted the medical director program. This wasn't done in the hurry after House Bill 2, and it's a project that's now being worked on by the team and by the secretary and the commissioner. I'd be remiss if I didn't bring up to you COVID claims. And I know that this is very, very big on a lot of people's minds. Is COVID a work-related injury? It can be. The definition provides for those type of illnesses to be compensable in Kentucky. It's a part of workers' comp. The real big issue is whether or not it's work-related. Now, for the first responders, the people at the ICU units and in the hospitals and stuff like that, that's a little easier task than it is, say, for the average employee that might work, say, the secretary that works in my office. But if you find it and it becomes workman's comp, then the big issue is causation, work-relatedness. How did that person contract it? Where did they contract it? But if they do qualify, the workers' comp law of Kentucky provides death benefits. It provides survivorship benefits. It provides the medical benefits, especially the concern that we have are long-term effects of COVID. Now, the governor and the Department of Workers' Claims has issued issued a new form. It's called a COVID 101. And what does this form do? I didn't have a chance, and I'll tell you, Lyle can send this out to everybody later. You can get it from the Department of Workers' Claims off of their pages, but it basically covers several job classifications. And you have to get a doctor to say you have COVID, which isn't hard to do. You've got the testing, and you have to translate why you feel where you caught it. How did you catch it? But it only includes certain job classifications. And I'm just going to run through this very, very quickly. Employees of healthcare entities, law enforcement personnel, emergency medical services, fire department, corrections officer, military personnel, activated National Guard personnel, domestic violence shelter workers, child advocacy workers, rape crisis center staff, Department of Community-Based Services, grocery workers, postal service workers, and child care workers. That's it. And if these forms are filed, the chief administrative law judge will review it, and there's a certain presumption to it that they're going to order the payment of temporary disability benefits, including some of the medical benefits. This is not the final step, but it's a step to try to get people money earlier in the process and early delivery of medical care and medical benefits. So I would encourage you all to take a look at that and check that out. There's 4 things to remember that's important in Kentucky workers' comp. Injured workers are still able to pick their doctors for treatment. Now, they have UR, and a lot of these doctors are opting out because it's such a hassle to treat workman's comp cases. But Kentucky still has, the injured workers still have the right to pick their doctor instead of having to be treated by the company doctors. Remember, there's single injuries, single traumatic injuries, but the one that a lot of people overlook are the cumulative trauma, repetitive work, overwork, shoulders, arms, neck, back, knees. And these are ones that a lot of your members will complain about, and it gets kind of blown off. Well, it's the aging process, or it's degenerative changes, whatever. Those people need to have that looked at. They have to give notice to the employer still. That's been on the books since 1916. And they're going to eventually they're going to have to have an attorney represent them in their cases. And that creates a little extra problem because especially ones in the rural areas, it's very, very difficult, very, very difficult to find the attorneys. And to get there, they have to go to the cities mostly to find it, or bigger cities than where they come from. Now, in conclusion, I'd like to say if you're any of your members, and I don't know if Lau can put this up on the screen, but if not, feel free to have my mobile number. Call me, any AFL-CIO member. A lot of times when you need help is early. It's not at the end, it's at early. Whether you have to go to their doctor for treatment, whether you have to, what can I do to get this medical treatment that the doctor recommends? How do I get that done? On behalf of KEG, our group, we look upon the AFL-CIO as our friends and members of our team. And we hope you look upon us as your friends and a member of your team. Thank you very much. And we continue to look forward to working with Bill in the battlefield of workers' compensation. Thank you.
Thank you, Ched. Thank you very much. We really appreciate all of your efforts on so many fronts. We talk about this stuff almost every day. The Workers' Compensation Board, the appointment of ALJs, the nominating commission, utilization review, the medical director regulation. This is really an ongoing project for us to really improve the system of workers' compensation. Something that Attorney Ched Jennings helped to actually design way back in what was it, the 70s there, Ched?
1986, the Administrative Law Judge Program.
And it's a constant battle to make sure that our workers that are injured on the job are getting the benefits, the medical benefits, and the compensation that they deserve. And it's a judicial process, right, Ched? I mean, you've got to go. It goes into the courts, almost all the time, unless
yes,
they come to a mediated settlement or there's agreement on the payment of the benefits. So you got to have good attorneys like Ched Jennings and people in his organization, which are spread out all across the state. And when someone needs an attorney for workers' compensation, we usually go to KEG and ask Ched to provide the name of somebody that could help out. So please, folks, if you have workers that are injured on the job, make sure that they get the proper representation right off the bat, because you need it. Without having good representation, you're really at the mercy of the insurance companies, which are obviously interested in paying less and delaying benefits.
Amen.
Amen. Well, thank you, Ched, and you take care. We'll be
Thank
talking
you.
soon.
Appreciate it. Bye, y'all.
You bet.